talk about what information to gather in a moment, but first we need to talk about the timeliness of information and what is not admissible before the appeals board. An appeals board is only allowed to consider or rely on relevant evidence when making their decision about your case. Admissible evidence is evidence submitted at the hearing either verbally or in writing. Written materials must be submitted at the actual hearing, not just attached to your application. In some counties, you're not permitted to submit any information along with your application. Also note that any conversations you had with the assessor will not be admitted for the board's consideration unless specifically discussed again at the hearing. If any information that you wish to submit at the hearing, such as an appraisal or a realtor's opinion of value, was prepared by another person, remember that the person who prepared it must attend the hearing so that the assessor and appeals board members can ask him or her questions about that information. Otherwise, only the raw data in that appraisal and none of the adjustments or conclusions can be admitted as evidence at the hearing. These same rules also apply to the assessor's evidence, except that the assessor's representative at the hearing may or may not be the same person who appraised your property. The person serving as a witness on behalf of the assessor's office can, however, be questioned by you and the appeals board regardless of whether or not he or she was the actual person responsible for your appraisal and assessment. This is because whoever testifies as to the value of your property on behalf of your assessor will be a Board of Equalization certified appraiser, and as such is fully capable of answering all pertinent questions about the evidence they have testified to. The method used for valuing your property will determine the type of information you'll need to gather. There are generally 3 methods for determining a property's value, but we'll discuss the one that's typically used to appraise residential property, the comparable sales approach. The backbone of your case is likely to be based on the value derived from the comparable sales approach, commonly referred to as the market approach. Let's look at this approach more closely. The market approach is based on the concept that your property's value is determined by the prices of other recently sold comparable properties in your area. We need to stop for a moment and talk about something referred to as the valuation date in relation to the value the assessor has put on the tax roll for your property. This is a date that will be particularly important when searching for comparable sales information to support your opinion of the value of your property. The valuation date can be defined as the date used by the assessor when establishing the assessed value of property. For example, when property changes ownership, the date of transfer is the valuation date. If you have new construction, the valuation date is the date the new construction was completed. If you're filing a decline in value appeal or an appeal of your property's base year value during the regular filing period, the valuation date is the lien date, January 1st of the current year. When appealing a calamity reassessment, use the date your property was damaged. When gathering comparable sales information, you need to look for sales of comparable properties that sold near in time to the valuation date for your property. This information can often be found by contacting local real estate agents and brokers, mortgage brokers, and real estate appraisers. Another very important source is your assessor's office. However, the data available at any of these sources must be verified to make sure it's accurate. It's strongly suggested that you drive by the properties you believe are the best indicators of the value of your property to see if the properties are comparable. But which properties are the best to use? Well, first, you must use a sale that was an arm's length, open market transaction. If not, the sale will not be admissible at your hearing as a comparable sale. An arm's length transaction means that the sale did not occur between individuals who knew each other or who are related. An open market transaction means that the property was advertised in the community as a property that was for sale. It's best to use properties that are most similar to your property in location, time of sale, and physical features. We'll discuss each of these items to adjust for when determining the value of your property. Location may be the most important item to adjust in your valuation. In fact, you've probably heard the real estate quip that the 3 key factors in your property's value are location, location, and location. You should therefore think seriously about the differences in location between your property and those that have sold recently. Generally, the closer to your property that the comparable property is located, the more likely it is that the same surrounding influences will affect its value. However, a nearby property may not always be comparable in location. A common example is two homes located very close to each other, but each served by a different school district. Also, one house may be located on a very busy intersection and the other on a quiet cul-de-sac. Remember, too, that just because two properties are described similarly on paper, you should take the time to drive by them so you can verify that they truly are comparable in quality, condition, and other respects. The closer the sale date of the comparable property is to your valuation date, the more likely it'll be a good indicator of the value of your property. Therefore, adjustments for differences between the time of sale and the valuation date of your property are critical if market prices are changing rapidly. If sale prices have declined since the comparable sale date and your valuation date, then you need to adjust the value downward to reflect the trend. You should adjust upward for time if the values are generally rising between those dates. The law prohibits the use of comparable sales that occurred more than 90 days after your valuation date for comparison purposes. Also, understand that listings of comparable properties are not considered as reliable indicators of value. You can go as far back in the past as necessary, but remember, closer in time is preferred and more relevant. With that said, let's discuss physical feature differences and generally how to adjust for them. Any physical feature differences between your property and the comparable sales should be considered. The differences in parcel size, zoning, or other structures like buildings and swimming pools should be noted. Once you adjust for these types of things, you need to look at the home specifically. Homes vary in size, shape, and quality. They vary in condition and room count. All of these differences need to be considered, but much of this work has already been done for you by your assessor's office. This is a good place to discuss where to find the information about your home and the comparable properties. Your assessor's office has the construction detail for all buildings in your county. This information is found on what's called the property's building record. It's this record we suggest you get for your property. Contact your assessor to obtain the building record for your property. There may be a small fee for this, and you may not be able to order it over the phone. If you go to your assessor's office to get the building record, you can have them explain specifically what's on that record. Since the same information is useful for the comparable properties, you should try to get as much of this relevant information as you can for those properties as well. Your assessor will generally make the property database information accessible to you, but you won't be given access to the physical records of comparable properties that you don't own without that owner's written permission. Remember, there's a worksheet on page 11 of publication 30 that will help you organize the information for comparable properties. I need to briefly mention the process of exchanging information with your assessor during the appeal process. An exchange of information is a formal process that can be initiated by you or your assessor. This exchange of information process is important because if either of you initiates the process, then only the information that has been exchanged can be used at the appeal hearing. This process is intended to provide you with information to understand your assessor's valuation method and the factual information they're relying on in their appraisal. By knowing this, you can be prepared to challenge that method or information. The same is true for your assessor, since during a formal exchange process, you must provide your information to your assessor prior to the hearing. On residential assessment appeals, these formal exchanges are not used very often. These exchanges have strict filing deadlines for initiating and responding, so check with the clerk of your appeals board and see publication 30 for more information. After the clerk of the board processes your properly completed application, you and your agent, if you have one, will receive a mailed notice of your hearing at least 45 days in advance. You're now ready to attend your hearing and present your case.